Hello everyone, I'm George from Ireland. So welcome back to the English Law channel, and I'm going to be looking at various reforms to co-ownership relating to the LPA 1925 and TLATA 1996. So before 1996 there were a number of tricky aspects to co-ownership, and so Section 3 of the 1925 LPA sought to make conveyancing more straightforward while still keeping it a bit adaptable. So a trust, remember, is imposed whenever land is co-owned. The 1925 LPA had a device called a statutory trust for sale. So trust for sale is when the trustees have a duty to sell the property unless they all agree to delay it. If even one of them decides to sell it, then it's going to be sold. So this seems odd, an odd way to hold land, and indeed it is. But it works if people are just trying to realise the financial value of the land. If the land was bought mainly as an investment, and selling it makes sure, well, you've liquidised the asset and now the trust has got the money. Anyway, but some people are investors, but other people, well, most people view land as a place to live. And many families lived in rented accommodation back then. So owning your own home only became the norm in the 1980s with selling off council houses. But this was much more difficult because after the Second World War, more and more people owned their own houses. So the importance of land to an investor is how much money you can make out of it. But that's not true if you're the owner-occupier and your main aim is actually to reside on the land. So a land holding device is something that pushes people towards selling it seemed to be bad news, because then the family would have to find a new home. They would want to be uprooted. And there were lots of divorces after the Second World War, and they didn't want to lead to more families breaking up. So co-owners were likely to squabble over whether the land should be kept or indeed should be put on the market. So the courts usually dealt with this by developing this collateral or secondary trust test, wherein the main purpose of the trust for sale was by definition selling it, of course, but they were willing to postpone the sale until the secondary purpose, that is, providing a house for the family, particularly children, could be attained when until the children had grown up. Remembering that the school leaving age was 14 just after the Second World War. Okay, so the Trust of Land and Appointments of Trustees Act came along in 1996, and this displaced the statutory trust for sale and in room of it introduced the Trust of Land. So this is a device which is neutral between selling it and keeping it. So the buyers could choose to create a trust for sale, but even those who now did so came within the machinery of a Trust of Land. So did the statutory trusts for sale that had been imposed automatically before 1996. So you don't really need to think about a secondary or collateral purpose in the Trust of Land because the trusts don't have a primary purpose. But bear in mind that a collateral purpose case law is still pertinent because it was important in framing Section 15 of TLATA, which has an illustrative, not an exhaustive list of the issues that the court will take into account when choosing whether or not to order land to be sold or kept. There's an application by an interested party under Section 14 of the Act. So let's look at the trustees' powers and duties. So TLATA has provisions which are crucial, and a trust of land is any trust where the property includes land. It doesn't have to be only land, though sometimes it is only land, and that's as per Section 1.1a. So it can be created formally or can be created informally. So we have got express trusts, resulting trusts, and constructive trusts. So the legal estate is vested in the trustees of land. So trustees do not have a duty to put the land on the market, but they have the power to do so. So they can sell it, they can keep it for the trust. That's sections 4 and 5. So they have the powers of an absolute owner, as per section 6.1 and 2. They can convey the land to the beneficiaries, or they can delegate their functions to the beneficiaries. If the beneficiaries are adults of sound mind and entitled in possession. The provisions require them to attain the agreement of a person before dealing with the land still hold good, except in charitable trusts, church trusts, and so on, as per sections 8 and 10. So under the old law, the trustees had to consult the beneficiaries in exercising their powers. and they had to effectuate whatever the beneficiaries wanted. But this was a major limitation on the powers of trustees, and this can be excluded in express trust. So trustees only have to seek the advice and opinion of the beneficiaries insofar as is practicable. So they can give effect to the wishes of the majority by the value of the beneficiaries, but they do so only in as much as that's consonant with the purpose of the trust. Okay, so let's think about the rights of beneficiaries now. Beneficiaries of a trusted land are those with the right to live on the trust land. However, there may be limitations to this right, or indeed sometimes it's excluded altogether. They could get compensation instead, as per sections 12 and 13 of TLATA. So the House of Lords said these were applicable in Stack and Dowd in 2017, the first time that they said they were, because they were looking at occupation rents. So anyway, so remember Lloyd Neuberger famously dissented in that judgment. In lots of cases, one or more of the co-owners, beneficiaries, wants to force a sale of land or indeed to stop it. So prior to TLATA, it was seen that the land was bought for the purpose of providing a house to be occupied by beneficiaries, and selling could be delayed in order to let people live on the land. So another vital provision here is Section 30. Replacing Section 30 of the LPA 1925 is Section 14 of TLATA. And that says a trustee or any person with an interest in land can apply to a court for an order about the exercise of the trustees of their duties. So if nobody's bankrupt and nobody disputes the bankruptcy, there are different results contingent upon the kind of case. So Section 15 says there are various issues to be considered by the courts when they look at these applications if there's no bankruptcy. So what was the intention of the person who set up the trust, and for what reason is the land being retained? Also, what would be to the advantage of any child who's living on this land, and are there any interests of any secured creditor that needed to be taken into account? All these grounds have to be considered by courts when they are deciding applications under Section 30 of the Law Property Act 1925, and the question is also there in as much as the cases are decided under Section 30, so much that's still relevant. Jones and Challenger 1961, Ray Evers Trust 1980, Ray Citro 1991, a very famous case. So cases in the last few years have broadened the interpretation of Section 15, the Mortgage Corporation against Share 2001. So it demonstrates that the post-1997 situation is decidedly dissimilar when it comes to the rights of beneficiaries as opposed to those of creditors. So the family house was owned by this married couple, Mr. and Mrs. Share. So Mr. Share was deemed to have charged his beneficial interest in order to secure debts to support his business. So he did this by forging his wife's signature on the purported mortgage of their joint legal interests. So clearly that affected her beneficial interests. The Mortgage Corporation asked for an order of sale with vacant possession when the debts were not paid on time, and because they wanted to claim the beneficial interest, but they couldn't claim hers. So applying Section 15 of the Act, the court found the mortgagee's interests was only one of the four factors that they had to consider. And so the court had broad discretion, and they could find to the benefit of families under Section 15 of the previous law. So this didn't show that the mortgagee's interest would take priority over children who are living on the land. So Judge Neuberger said that pre-TLATA cases were no longer very persuasive when it came to this issue. So we also have to make sure that there's no presumption under Section 15, to make an order for the creditors of any beneficiary. But and that's still good law. The Court of Appeal heard Bank of Ireland home mortgages against Bell 2001, and they said that the creditors will normally get their way. So there are policy reasons why we do it this way. The credit system requires secured lenders to know that they're going to be able to get the security, the collateral, if the debtor repeatedly fails to pay on schedule. Otherwise, nobody will lend a penny. So if the creditor fails under Section 15, he can make an application under Section 14. And okay, he can then go to make the beneficiary bankrupt, and so the court has discretion under Section 15. Section 14 is not governed by Section 15. It goes under the Insolvency Act, Section 335A, so 1986 Act. And so after a year to sort yourself out, it does favour the creditors. Now, they said that there might be some extraordinary circumstances which they don't do that, but that can't be the ordinary situation. Yes, it's usually sad when there's bankruptcy, but it has to be much worse than that. It has to be really exceptional for them not to apply these rules. Can't be just feeling sorry for people. Ray Bremner, 1999, was a case of this. So the trustee in bankruptcy can make an application under Section 14, and it's vital to know that Section 15 no longer counts when the court has to apply things. Okay, so that's probably enough on TLATA for the moment. Bye.